So, a very good morning to everyone present here today. Welcome to today's CDPP discussion on understanding the Indian legal system for the marginalized communities who have been incarcerated under the terms of petty crimes. A little brief about CDPP. The Center for Development Policy and Practice is a research organization that is working towards influencing public policy in India. The Center for Law Economics and Society is an initiative under CDPP that seeks to research on the legal landscape as well as work on it. Today, we have Professor Faizan Mustafa, who is an Indian academic and legal scholar. Presently, he is the Vice Chancellor at Chanakya National Law University, Patna, and is the former Vice Chancellor of Nalsa Law University, Hyderabad. Like I mentioned, today's discussion will revolve around access to the Indian justice system and how it affects the vulnerable communities who are accused of petty crimes. We have a set of questions to discuss with Professor Fazan sir, and we will end it with a follow-up questions from our members here who are present. So, Professor Fazan sir, a warm welcome today. Please let us know if you can start this
Yeah,
discussion.
please go ahead.
Yes, sir. Sir, we want to know that how do you define this vulnerable population when we talk about incarceration, and what specific challenges do these groups face in India?
No, first of all, poor.
Hmm.
The most vulnerable people in a criminal justice system are poor. And it is this group which is overrepresented in our jails. And then, of course, you have SCs and STs, and then you may have minorities. In fact, for Muslims, it is said that the only place where they are more than their proportion in population is in jails. So you can say that religious minorities, particularly Muslims, and SCs and STs, and poor people or poorer section of our population uh, taken at a higher level of generality. Poor of any community is poor.
Hmm.
So poor Hindus are there, poor upper caste people are also there, and uh, and this is what it is in number of other countries as well. That generally the underprivileged people end up in the web of criminal justice system because they may not have enough resources to defend themselves. They may not afford high fees of good criminal lawyers. And many a times their cases are not represented well. Then we came up with a law that right to legal aid
Hmm.
uh, is there for each one of them. But you know that the lawyers who work for legal aid, most of them are not professionally very sound.
Hmm.
So even when you have some semblance of representation by some lawyer, that representation does not match the prosecution, where the might of the state, is at the disposal of public prosecutor.
Yes, sir. Sir, so when we are talking about institutions currently, how do you think that the colonial laws have shaped into affecting the vulnerable population in our country?
No, you see, most of our laws continue to be colonial, so much so that even the three new criminal laws, which many of us say that they are indigenous, have largely copied from the CRPC and IPC and the Evidence Act. And over 90%, maybe more than 95%, we have retained the colonial era laws, except that in the Code of Criminal Procedure, we had already brought in a new code in 1973, which also had retained most provision of the earlier Code of Criminal Procedure. In the new laws, you see some changes in the Code of Criminal Procedure, but hardly any change in the evidence law, and just some minor changes in the Indian Penal Code, now named as Bharatiya Nyaya Samhita. So, colonial period was dealing with the subjects. They were not dealing with the citizens. So, let's say that they had some criminal tribes laws that certain members of tribes, by virtue of their membership, are to be suspected of involvement in criminal activities. We repealed that law, but you know, this continues to be in our mind that some people, because of their birth, are likely to commit crimes, which is a theory given by Lombroso in criminology and has been long rejected. This whole idea that criminals are born, or look at their eyebrows and look at their nose and look at their cheek and lips, and if they have these features, then they are likely to commit crimes. This is no more considered as authoritative thesis on why people commit crimes. We now believe that it is the environment, it is the society which plays a huge role in why people commit crime. And therefore, criminals are made rather than criminals are born. And maybe in many a times, all of us may be responsible for their criminal acts. So there were number of laws. There continue to be many laws which have a colonial legacy, where the model was to control the population. In a constitutional democracy, in a liberal progressive country, where citizens are the sovereign, so to say, the constitution begins in their name, we the people of India, ultimate sovereignty resides in them. This was not so. Their object was that the imperial power should be able to sustain itself through a control model rather than the liberty model, isn't so? So, post constitution, ideally, all criminal laws and other laws must be made compatible with the constitutional ethos, with liberty and with democracy and with rights. The mere fact that we retain sedition is one big example. And you will be surprised that in the original Indian Penal Code, sedition was not there. It was only subsequently when the Muslim ulema gave fatwas to fight against the British government. Now, what is a fatwa? Fatwa is just an opinion. So there is no violence. Mere statement is a fatwa, isn't so?
Yes.
So how do you punish people just for their speech, what they write or what they speak? Therefore, this section 124A, was inserted, creating a crime of sedition. When we are making our freedom of speech and expression as a fundamental right, then this whole idea becomes inconsistent with your freedom of speech. And that is why Supreme Court in Kedarnath case said that unless this speech leads to some violence, we should not punish people for sedition. There have been cases where somebody said Khalistan Zindabad or Ban ke rahega Khalistan, after Mrs. Gandhi's assassination, and Supreme Court said it is not sedition. So, and then recently, Supreme Court had to put a kind of a stay on prosecution of people on sedition. So, when we changed the penal code, we just dropped the word. We brought another term and largely retained the same provision. So, what the country's criminal justice system need to decide is that whether you continue to believe in a colonial imperial idea of controlling population through the instrumentality of criminal justice system, or you want to humanize your criminal justice system and make it consistent with the idea of civil liberties.
Hmm.
This is a big dilemma which is to be resolved.
Dilemma. Yes, sir. Sir, when we talk about again the debate between, colonial rules as well as the human nature or the liberty aspect of it. So currently, what do you think are the legal loopholes in the current judicial system that particularly affects the marginalized? For example, the poor that you have mentioned, be it urban, be it rural. But what are these legal loopholes that they are getting stuck
No,
at?
the insistence, for instance, this
Hmm.
whole idea of bail bond. If I'm a poor people, I know only poor people. So who will be willing to come forward to sign as a surety? So for rich people, you have bail. For poor people, you have jail. You look at the recent Pune accident case. The judge asked the accused to write some 300-word essay
Yes, sir.
to give him bail. You have another case of Mohsin Sheikh, where the bail was given. Here is young boy who has been killed, an engineer, and then the court said that because he was wearing pastel green shirt or kurta, that the color of his kurta, provoke the accused. Now, this is absolutely unknown to grave and sudden provocation that because of somebody's, color of cloth, one can get provoked. So, and ultimately, I think I have not followed it, but probably all of them probably got acquitted as well. So the whole idea is that rich can get away and poor people languish in jails. There have been cases where poor people have been there for more, for a longer period of incarceration than the maximum punishment for the crime
Yes,
with
sir.
which they were charged or they have been convicted. Uh, in a criminal trial, you have two stages of a trial. One is called determination of guilt, whether you committed a crime or not. Now, this will involve law of evidence because proofs are to be called, evidence is to be summoned, intention is to be proved, knowledge is to be proved. If there is a slightest doubt, the benefit is to be given to the accused. Now, once you have been found guilty, the first stage of criminal trial is over. Then the second stage is to determine the sentence. Now, at the time of determination of sentence, how sentence is fixed? So let us say for the offense of theft, the law will prescribe maximum punishment of 3 years. But maximum punishment of 3 years is generally not given, is not to be given. So the court will look at the mitigating factors and look at the aggravating factors. So if you are a sole breadwinner of a family, if you are young, if it was your first offense, it will operate as a mitigating factor. If you are poor, your children were starving, and you have stolen a bread to feed them, it will operate as a mitigating factor. By the way, in Islam, if you steal and you are hungry, then this is not considered theft. So aggravating factor will be you are a habitual criminal. It is not your first offense, but number of times in past also you have been convicted. So the judge generally starts from the midpoint. So midpoint is 1.5 year, 1.5 years of punishment. He will look this side and that side. If more mitigating factor, he will reduce it. If more aggravating factor, he will increase it. So this is how the punishment is to be given. There have been cases, where the maximum punishment would have been, let us say, 3 years or 7 years. but people are in jail for 10 years, for 12 years, for 14 years. There have been cases where people have been convicted and they have undergone the entire period of their punishment, not released. And the worst, the Bhagalpur blindness case, you know, by piercing needles into the eyes of prisoners, they were blinded. So we have been absolutely cruel with the accused. While our father of nation was telling us, hate the sin, not the sinner. Churchill has made a very interesting statement. How do you judge a civilization? And he says, look at their jails. How do you treat your ordinary citizen is not the test or yardstick. How do you treat people who have been found guilty? And the condition of our jails are horrible. They are overcrowded. Uh, the facilities are poor. The per day money which is spent on their food is barely sufficient. It is only for people like that person who had gone to England, escaping Indian criminal justice system, and when he was to be extradited to India, and the question was that he would be put in the Arthur Road jail in Mumbai, then the pictures of that jail were sent, this much of sunlight is coming and this much of, ventilation is there. But that is not a reality of all our jails. So the subject matter is important. How do we really treat people when they have gone against the law and they have been found guilty? That determines at what level is our civilization.
So, sir, you mentioned in your answer about the families of the incarcerated as well, right? So, when we see these people who are from the vulnerable communities and are languishing in jail, we know the physical and mental toll that takes on them. So, but what about the family? What is the economic or social stigma or other challenges that the family also has to face?
You see, it depends. If any member of your family is involved in the ordinary crime, you still carry the stigma. That is a whole difference between the civil law and criminal law, that in civil law, you don't have a stigma. But if your family member is involved in some terror crime, then that family is finished. And they won't be able to come out of that shock. Their own family members, their own neighbors will disown them. The fundamental rule of criminal liability is that the liability is individualistic. You cannot punish the whole family for the crime committed by a son or by a father. But in cases like this, the whole family pays the price. And that is really sad. I remember Justice Surya Kant's one very interesting judgment, which has not been as widely reported and appreciated as much it deserves. He was a Punjab and Haryana High Court judgment. And to one prisoner, uh, I think he was in jail for many years, or probably a life convict. I'm not, exactly recalling the details. But the question was whether he, or particularly his wife, have a right to access to each other for their intimate relationship. And I salute Justice Surya Kant for giving such a liberal judgment that she said, yes, that right is there. Even though your liberty is otherwise curtailed, but you need to provide that kind of space and freedom to husband and wife. Uh, if they want to make love, let that opportunity be there for them.
So,
Yeah.
sir, my question is that we know that the BNS have come into effect from the 1st of June. However, there are many police stations that are still continuing to record the crimes under IPC. So, sir, what is the confusion here?
No confusion is there. They're not
Okay,
recording anymore. This happened maybe in the initial
initial.
days, but
Mm-hmm.
no more. They are recording it under the new law.
BNS.
Most of the crimes are the same.
Yeah.
Only the numbers of sections have changed. And that is why for people like me, it is very difficult. For me, murder remains defined in section 300. For me, I
Okay.
really don't know where it is defined, maybe 100 or somewhere else. So, largely, it is the old wine in new bottle, except that some positive changes are there, some regressive changes are also there. So, on the positive side, for instance, you have the community service coming as a form of punishment.
Yes.
This is a welcome change. And if it can reflect the change in our understanding of criminology, it would be great. We have to see how the courts awards this sentence of community, service. Similarly, videographing of the crime scene on the mobile, I think is a good provision. The provision of having a forensic lab in police stations is a good provision. Writing all the details of all the people who are, in custody of the police is a good provision. Zero FIR is a good provision. There are many welcome changes in the Code of Criminal Procedure. In the evidence, I said these are cosmetic. The digital evidence, etc., largely it remains the same. So the problematic side is, should we cover the terror crime, which is a special crime within the BNS? My take is that it is better that special crimes are dealt under a special act. Uh, Similarly, this whole issue of sedition in new avatar, where financial means, you don't know what financial means are there. So there are words which have not been properly defined. One of the fundamental rule, the classical thumb rule, to look at the legality of a criminal justice system is that the narrowest possible definition of crime is to be given. The whole idea is that everyone should not become a criminal. If all of us become criminal, the criminality will become respectable. So Rashad is also criminal, and Albaz is also criminal, and I'm also criminal. Everyone is a criminal. Sejal is also criminal. Then फिर तो criminality becomes really respectable in the society. So to reduce the number of criminals to the minimum, who will carry that stigma? Who will will be in a way looked at as those who went against law. uh, you can't be increasing that number, and therefore you should not have presumptions of guilt. In last 25-30 years, we have created several presumptions of guilt. Ideally, it should be for the prosecution to prove whether X has committed a crime. Now we say we will presume you have committed a crime. Now you prove your innocence. Now this is shifting of burden of proof is wrong. It goes against the thumb rules of criminal justice system. So, extended period of custody, there has been some clarification, but not a very clear categorical clarification. What does it mean? But if the period of custody has gone to 60 days, that's not right. but saying that people who have undergone one third of the punishment which they are likely to get would be released on bail if they are of a certain age. I prefer that it should be extended to everybody. So there are some positive changes. There are a few things which may require a review. When you make a law, it does not mean it is written in stone, it can never be amended. So there is always a scope of improvement of law, and it should be improved, and I'm sure it will be improved someday.
Okay. Thank you, sir. So, our final question for this discussion is, other than the institution of police and the courts and judiciary, what are the other stakeholders involved, and how can they support that there is fair treatment when it comes to the marginalized communities who are accused of crimes?
So you see, is police investigation.
Hmm.
Investigation is a very important arm of criminal justice system. The jail authorities. So we have not changed the Police Act, which is a colonial piece of legislation, is still based on the hierarchy. So the lower officers have to follow the senior officers rather than follow the constitutional norms. It is a control model legislation. And press, I believe the kind of reporting they do of crimes is absolutely horrible. You are not supposed to become an investigator yourself and do a media trial of an accused. But the way police presents, uh, crimes today, including the encounter crimes. So I was on NDTV recently, where someone was killed in a police encounter in Maharashtra, and I registered a very strong protest with NDTV, the way they were showing that he was in a police van and then he took water like this and then he took pistol like this. I said, what are you doing this drama bazi thing? Because it ultimately affects his right to be defended as an accused. What has happened to Nithari, episode in Noida, and to Ayushi, murder, and several other high-profile cases. So, media has a right to report, but they are not supposed to report such details of a crime which have a bearing on the defense of by that accused. Because you have to understand, in a criminal justice system, one little man called accused is pitted against the might of the state. What is the crime? State defines. How much punishment will be there? State defines. Who will register crime? Police. Who will investigate crime? CBI, ED, or IB, or whatever police agency. Who will try you? Will be judges appointed by the state. Where will you be kept? In jail, which are state institutions. And therefore, since this one man is pitted against the might of the state, it was thought that state may abuse its power, and therefore criminal law was deliberately tilted in favor of the accused, so that the state does not abuse its power. That is why presumption of innocence. That is why no retrospective operation of criminal law. That is why no double punishment for same crime. That is why the rule that no one shall be compelled to be a witness against himself. That is why, if two versions of the prosecution story are possible, one favoring the accused, another going in favor of the government or prosecution, the one which favors the accused, is to be accepted. That is why the burden on the prosecution to prove the case beyond any shadow of doubt. Now we are diluting these principles, and this dilution is not recent. It is not that in 10 years this happened. This is happening for last 30, 35 years.
Thank you so much, sir. I think your expertise is going to help our discourse for sure.